We welcome author and CG Chair of Global Security at the Balsillie School of International Affairs, David Welch. David will be our guide each day this week as we explore important justice issues on an international scale. We begin today by setting the stage. What exactly does justice mean in a global context? And if we can find a universal definition for it, how would that translate into law? Hi there.
Nice to be here.
I want to begin by reading a quote. This is from a justice conference that was held in Germany last year. Here's what it said. We encounter justice in the most diverse domains as an ideal to which different and often conflicting social actors appeal. Most of our judgments about what is just are intuitive. For example, when we say that in society, whether in the education system or the labor market, equality of opportunity should prevail or that performance should be rewarded. David, these types of judgments about opportunity are based on influences around us. So in a world with 190 plus countries and 100 more cultures than that, how do we come up with an international definition of justice?
Well, it's hard. We all have a sense of justice. It's hardwired into us. It's part of human nature. That much is clear. But what we share is a concept of justice, a sort of general, vague sense that the world is just when certain things are in balance. What people disagree on is conceptions of justice. In other words, detailed unpackings of what exact state of the world would actually be fair or balanced or just in the appropriate way. So it's a species of the concept of right, which again, we all have a sense of right and we all have a sense of good. Justice is particularly interesting because, to my mind, it's easiest to think of it as a fit between entitlements and benefits. In other words, the world is just, things are just, when people have what they're entitled to have. So the question then is, well, what entitles anybody to have anything in particular? And that's where international justice is especially complicated and especially interesting because, as you said, 192 members of the UN, thousands and thousands of different cultures, they all have their own slightly different understandings of justice at the level of conceptions, at the detail level. And we have to try to work that out somehow internationally. We have to get people to agree on specific understandings of justice in cases when they're going to be inclined to disagree.
One of the things that goes hand in hand with justice often is equality. And again, we sort of run into the conundrum of definitions and different interpretations of equality, the equality of results or the equality of opportunity. To what extent does a Western notion of equality of opportunity prevail in international justice?
It prevails to a large extent because the international system was basically set up by Europeans in a Western way, right? So there's been sort of a built-in privileging of European understandings of justice right from the get-go. Having said that, of course, the idea that every single person is entitled to exactly the same set of equalities, that's a very recent invention. And even in Europe a few hundred years ago, nobody would have thought that. People would have thought that class distinctions were relevant, that somebody from a higher class deserved much more than somebody from a lower class, and there was an injustice if somebody from a lower class had the same as someone from a higher class. There are similar distinctions at the level of gender, race, you name it. All kinds of differences in people's characteristics used to be seen as justifying differences in treatment or differences in entitlements and benefits. So there's been two things. One is the sort of the general spreading of European ideas around the world, and the second has been the tendency to move towards a more individualistic, more strictly egalitarian understanding of justice.
You know, the argument's been made that justice can also be understood, and it is understood as a political concept, that justice links politics and ethics together. So explain for me how that works, how that relationship works.
Well, justice is political in the sense that you have to work out notions of justice in political documents, in political structures, in constitutions and laws. And courts are the places where decisions about justice get made authoritatively. And so these are all political processes. Now, globally, we don't have a single state, a single world state. So there's no highest authority globally that we can appeal to make decisions about justice. Although that's changing in certain respects. We're starting to see the beginning of global institutions for making decisions about justice. But there are many different countries, each of which have their own sets of laws and so forth. And so when you step back and look at the world as a whole from the perspective of justice, people are inclined to take one of two perspectives. The first is what we call the Cosmopolitan Perspective, and that's the view that is most clearly associated with the Western European radically egalitarian view. Everybody has the same set of basic human rights. Everybody ought to be entitled to the same set of liberties and so on. Okay. And then there's the communitarian view, which says, well, no, really we should privilege individual communities' understandings of justice. And so if they do things very differently, say in Saudi Arabia, that's just for them. It might be unjust for us in Canada because we're basically liberals, but in Saudi Arabia, for example, if women aren't allowed to drive, that's perfectly fine because the local norms basically establish the entitlements. And that is not one of the things that women are entitled to yet in Saudi Arabia.
You bring up Saudi Arabia, and countries like that make me think of what kinds of role religious beliefs play into justice. How much of our interpretation of justice is based on religious beliefs?
If you go back far enough, it's very significantly influenced by religious beliefs. Most of the dominant Western schools of thought in philosophy either had their origins in religious thinking or were heavily influenced by religious thinking. So if you scratch deep enough, you'll find, for example, a lot of Judeo-Christian roots in modern thinking about human rights. Of course, that's many steps removed. For centuries now, we've basically been unpacking these notions in very secular terms, which had the benefit of increasing their salability and their attractiveness globally. You certainly don't want to go around the world and saying we want to establish notions of international justice that are firmly rooted in the Judeo-Christian tradition because you'll lose most of the world right off the bat. But if you can represent them as secular, or at least non-denominational, at least equally applicable to people of any religious tradition, they'll have much, much more traction.
I want to read one more quote for you. This is political theorist John Keane interviewing Iranian philosopher and public intellectual Abdul Karim Suresh. This was back in 2006. And here's how he framed the universal definition of justice, the question about that. Here's what he said. The word justice, in Persian as in English, there is no cognate verb for justice. We have laughing, kissing, arresting, or murdering, but we do not have justicing. The verb to justify, as when we give reasons for doing something or when we line up in text in an orderly way, is not the same. It is as if justice is condemned to being an abstract noun. That enables all kinds of people to speak of justice in various and conflicting ways. It even allows rogues to take refuge in talk of justice. Think of U.S. Vice President Dick Cheney's declaration that waterboarding, the torture underwater and forced confession of prisoners, is an act of justice. Or President Bush, I want justice, he said shortly after the September 11th attacks. And there's an old poster out west, I recall, that said, wanted, dead or alive. Aren't these examples of the way the notion of justice is demeaned by its abstractness? How do you respond to this question, David?
Well, it's an insightful quotation. There's a lot packed into it, and I think to do that justice, we would have to spend a lot of time talking about it.
But
a couple of points. One is that it's not strictly speaking true that waterboarding an al-Qaeda suspect would be understood by anyone as a form of justice unless you knew in advance that that person was guilty of a crime that justified that kind of personal pain retributively. And if you had a standard retributive understanding of justice, then you might say that that is just. But in fact, when you waterboard somebody, they haven't been charged with a crime, they haven't gone through a court, nobody has found them guilty of anything yet. You're trying to get information out of them. So that's not justice, that's something else. If they were tried and found guilty, then maybe some penalty that inflicted some pain would be appropriate. The other thing that's interesting about that quotation is it quite rightly flags the abstract nature of justice. And any court facing any case in any context is going to have to take concrete case, abstract principles of justice, and try to decide how best to apply the abstract principles to the case. And there's no simple template. It's not a mechanical exercise. Even in what appears to be the simplest case in Ontario court involves some judges trying to make some reasonable interpretation of abstract principle to concrete cases. That's always true in any case involving justice in any context, no matter how rich the institutional context in which judges do that.
But I guess there's a sense that the word justice is used it's thrown around quite loosely and easily, and it seems to have, a definition, if you will, from the position you're standing in, that there doesn't seem to be an agreed upon definition. Given that, I mean, this is a real conundrum we come up against, trying to come up with a universal definition of this term, is it not?
Well, it depends on the case, right? So some areas of our lives are very well worked out, and there are very clear principles of justice, and you can spot deviations from them easily. Other parts of our lives, that's not the case. In international politics, this is especially clear. Right? We have detailed entitlements and obligations, for example, under the WTO, increasingly under human rights laws. But other aspects of international politics are very, very badly worked out in this way. So, for example, a lot of territorial claims persist around the world because the principles for resolving territorial claims between countries are not universally agreed upon. Terrorism, right? One man's freedom fighter is another man's terrorist. Well, that makes it very difficult to establish sort of an international rubric for assessing, justice and injustice, trying terrorist suspects, and so forth and so on.
Does it become then, I mean, if we could come up with a universal agreement on what justice means on the international stage, does it still make it almost, I don't want to say impossibility, but extraordinarily difficult to then translate that into law?
It does, because there's no international body to pass law. So international law is itself handicapped by the fact that we don't have a global legislature to pass international laws. So international laws come from a rather different place than, say, Canadian law. International law comes from treaties duly ratified between sovereign states. It comes from the prevailing practices and customs of international society, basically British common law scaled up to the global level. And interestingly, it can also come from the opinions of learned jurists and scholars of international law. It's one of the strange areas of human life where professors are actually taken seriously and what they have to say can actually be used in decision-making about what's right and wrong. So it's a much vaguer, somewhat shifting body of sources of law at the international level and domestic law, but that doesn't mean it's not detailed, and it doesn't mean that it doesn't provide useful ways of resolving disputes. Increasingly over time it does. International law is becoming broader, more complicated, more well worked out, and in the grand scheme of things, more widely accepted by people globally.
Well, interesting that you say that's become more widely accepted, because a couple of years ago, you probably remember this, a Spanish judge made a decision to investigate 7 Israeli officials over a deadly attack against Hamas, and had nothing to do with Spain. And this instance sort of renewed the debate about how far the arm of justice of Spain or of Europe should go. So how do we decide who gets to be the justice makers?
This was an interesting case because this particular judge, Judge Garzón, if I'm not mistaken, he took it upon himself to try to promote a principle of universal jurisdiction. Now, this is an interesting new idea that actually quite a lot of people, and especially international legal theorists, are in favor of. The idea is that certain crimes can't be tried properly by states because you'll never find impartial jurists within states to do it. So people anywhere in the world should be susceptible to prosecution and judgment by judges anywhere in the world for certain sets of crimes. And Judge Garzón was actively trying to get indictments and have people extradited to Spain so that he could actually try them for crimes that didn't happen anywhere near Spanish soil. The most famous case was General Pinochet, the dictator of Chile, and Judge Garzón actually requested that the British hand him over when General Pinochet was visiting Britain. That particular idea has not been enshrined in any body of international law. The principle of universal jurisdiction was deliberately passed up when the International Criminal Court was being negotiated. We're not there yet. 100 years from now, who knows? It may be that he was simply ahead of his time.
I guess it raises a question, though, that people are sticking their noses in business that has nothing to do with them.
Well, the question is, does anything not have anything to do with them, right? We live in one planet. It's increasingly a globalized world. Things that happen on the other side of the planet affect you and me, more so than used to be the case, and that's the trend. It's going to be increasingly that way. So as time goes on, it'll be easier and easier to justify attempting to iron out inconsistencies in the treatment of criminals in various parts of the world.
Okay, we have about a minute left. I just want to ask you, this disagreement over the meaning of justice, how does it manifest itself in the international justice system as it is now?
Well, pick an issue and I can give you an illustration. Is there a particular kind of issue?
You tell me what comes to mind.
Well,
You're the
let's
expert.
say, for example, human rights law. All right, so in some parts of the world, especially North America, Europe, some people, politically progressive typically, think that we ought to have aggressive human rights laws that justify international intervention anywhere if there's the slightest whiff of discord. And so the doctrine of responsibility to protect was really the latest doctrine promoted by this particular school of thought. Well, in other parts of the world, people are very skittish about this. And they see that as a license, giving somebody else a license to intervene potentially in their own domestic affairs. So there's a standoff basically between countries such as the Italians or the French or the Dutch, and on the other hand, the Chinese or the Russians. Big disagreement on exactly whether something like an international intervention in Libya or Syria would be justified on the principle of responsibility to protect. We don't have closure on that kind of big issue yet.
Okay, David Welch, we'll leave it there for tonight. We'll see you again tomorrow. Thank you.
You're welcome.